And there's also a public battle to win over public opinion about how people perceive this case. And it's a test for Alvin Bragg. The country doesn't know him. They are now going to very much get to know him. So his introduction of his case, his argument, his evidence will be crucial in the coming hour.
And as Ricky talks about the timeline, I started to think about there's the Georgia case in Donald Trump's efforts to try to get in the way of the election that's going on in Georgia, and then, of course, the special counsel's work. So there are a lot of other legal developments that may gallop ahead of this because a lot of people think those cases on their face are stronger and have more of him at the center of the stage. You know, his lawyer in the documents case now has been asked by a judge to testify, piercing the attorney-client privilege with the crime fraud exception, so that he now has to talk about conversations he had with Donald Trump about whether Donald Trump asked him to obstruct justice with respect to those documents. That is serious stuff, which, given the timeline you're talking about, may gallop ahead of all of this.
And in New York, we have to remember, if we just look at Alan Weisselberg and the Trump Organization, you went from July of 21 to November of 22. So we're really talking perhaps a year and a half.
But
Go ahead, Jeff.
Aren't we assuming that the former president, he considers himself a fighter, we're assuming that he's going to want to fight this? Perhaps there is another way for them to handle this case, given the other cases that are sitting out there that could potentially lead to more legal jeopardy.
You're talking about a plea deal.
Yeah.
It'll never happen.
Why?
Because it's Donald Trump. He would never, under any circumstance.
But if you were representing him, would you advise him to, hey, let's make this go away?
Well, it's not going to go away because he's running for public office. And so he does not want to have a conviction behind him. And in addition, he keeps saying that he has done nothing wrong. I cannot imagine in my wildest dreams that Donald Trump would offer a plea of guilty to this case or any other case.
Just throwing that out there.
Well, it definitely got me up there.
Well, it is noteworthy, the irony, and I think you can use that word in this case, of someone who tried to carry out a hush money payment to make this all go away, and now it's turned into the first ever.
And people who really know Trump say it's that element of this case that really unsettles him, whether it was Access Hollywood and that whole experience in October 2016, or Stormy Daniels and how this has played out over the last 5 or so years. Trump has tried to keep his personal life, in certain aspects of it, contained in various ways over the course of his life. And he doesn't love when this stuff comes to the fore, even though he is defiant legally and politically right now. Just look at what we're seeing right now on screen. Look at Trump's face. Look at his body language. I'm just a reporter, but it tells you something sometimes just to see how someone's handling the moment.
And that goes back to what we were talking about earlier. For some portion of the country, they will think no one is above the law. No matter how grand you are, how many buildings have your name in front of them, no one is above the law, which doesn't mean you're guilty, just means no one's above the law and you have to go through the legal process. And others will look at this and speak of it in the apocalyptic language that Donald Trump used in his tweet on the way down there, or whatever his Truth Social posting, which was, how can this happen in America? Speak in apocalyptic terms, where this is not just a single person, but this is evidence of a corrosion in the American system. And when you raise it up to that level, you inject into the system the kind of energy that we saw after the last election that had such dangerous results.
I want to bring in Scott Frederickson, the former federal prosecutor who is paying attention to this. They can talk about the legal jeopardy that the former president faces. Scott?
Well, that's right. And I think we shouldn't forget that the defense of Donald Trump right now is probably feeling fairly confident that they have a legitimate shot to knock this case out on their motion to dismiss on the grounds that misleading business, falsification of business records designed to mislead for purpose of a campaign, federal campaign financial obligation doesn't qualify as fraud. I think they're going to argue that that was misleading, but it's not fraud. Now, They could lose that, but I think they're feeling very confident they can knock it out. And so they're going to go forward. And I think the second thing to keep in mind here is that there may be 34 counts here, but they're misdemeanors elevated to low-level felonies. Highly, highly unlikely that even if convicted on all 34 counts that the former president would ever see any jail time. So there's no real motivation for the president to do anything but to do his very best to knock this case out.
The breaking news at this hour, Donald Trump himself pleading not guilty to 34 counts of falsifying business records in the first degree. Our own Scott MacFarlane was inside an overflow room, the first to report that it was Donald Trump himself who said in a loud voice, not guilty. Scott MacFarlane also reporting that the district attorney, Alvin Bragg, inside the courtroom, sitting in the front row. We're still waiting more details about what comes next. Ricky?
One of the things that we have to remember, and I always repeat myself, but I think it's worth repeating, that in a court of law, Donald Trump is entitled, as any other citizen, to the presumption of innocence. That is not true in the court of public opinion. There's no such thing as the presumption of innocence out there in the other world. So it brings us back to John Dickerson's point that we have both the legal world and the political world, which I say are colliding here. So Donald Trump can go forward with all of the protections in court, and he will go forward with his lawyers and contest the law of this case. The law of this case is going to be really the big question, because if it gets to a Manhattan jury, I think we know what the probability of a guilty verdict might be.
Because Manhattanites tend to be more Democratic in their political affiliation?
Correct. And there has certainly been enough noise against Donald Trump in recent times in Manhattan. But the law is going to be what determines if a jury gets this. Now, while saying that, too, I just said he's entitled to the presumption of innocence, and the defense knows it only takes one juror to hang that jury.
That's why Donald Trump has said himself he would favor moving this trial to Staten Island, where there tend to be more conservative voters in the borough of Staten Island.
Which is so funny because it's not like Texas. You know, Staten Island, it's more conservative by New York standards.
Yes, absolutely. I want to also bring in and bring up this point, follow up on this point, I should say, rather, that Scott talked about. Why and under what basis can Donald Trump's attorneys make the case to quickly dismiss these charges? What legal standing do they have?
Well, they always have the right to file a motion to dismiss about the law. They also have another right that is peculiar to New York, and it's called a Clayton motion. And what a Clayton motion is that you say it is in the interest of justice, regardless of the merits of the case, to dismiss this case. So they have two ways to go about it. One other part of the motion to dismiss that we know, according to Donald Trump's lawyer, Joe Tacopina, that they're looking at is not only do they believe that there is not a law that prevents this case, that allows this case to go forward, and that this is a misreading of the law, but they also claim that there's a statute of limitations issue. All of these are ethical and proper motions for a defense lawyer to make. Whether or not they're going to be granted is way down the road. And if they're not, it's going to a trial. Because, Jeff, I know you were provoking, but there is never going to be a plea.
And just to build on Ricky's points, when I was talking in the last 24 hours to Trump's attorneys, they say they're going to make a case in the dismissal motion that Trump is being selectively prosecuted in this case, that because he's a former president, a Republican, that he is being prosecuted for that reason. So that is going to be at least part of the argument they are making as they try to dismiss this relatively quickly in the coming weeks.
Just want to note now, Donald Trump has been inside that courtroom for about 40 minutes now. He entered at about 2:30 Eastern time. According to our own Scott MacFarlane, who witnessed the proceedings inside from an overflow room, the Manhattan prosecutors accused Donald Trump of trying to cover up a potential sex scandal during the 2016 presidential campaign with hush money payments. They were bumped up, these charges, to Class E felonies, meaning that this conduct essentially was intended to conceal another underlying crime. This now opens Trump up to not only be the first president or former president indicted, but now to face criminal charges. We are awaiting many more details from what's happening inside this courtroom, as no doubt his attorneys are trying to move to dismiss this case. Dates set, more particular specifics about the indictment that we still don't know. All we know, according to Scott McFarlane, was that it was Donald Trump himself who said in a loud voice, not guilty.
And as Ricky so eloquently explained, this is going to take a lot of time. We're looking at weeks and months ahead. And politically, John, I'm so curious how this is going to play out as you have an ongoing Republican presidential race. What's coming up this summer? Debates, primary debates. Then you're going to have major election nights next year in 2024. And so you're going to have an ongoing potential trial while someone runs for the presidency of the United States and could even be convicted of a crime down the line and serve in the American presidency.
And not just in this case. The E. Jean Carroll case is, I think, being heard next week, where Joe Tacopino is defending him against a charge of rape. A civil case. Then there is the January 6th case. There is the documents, the classified documents found at Mar-a-Lago, the Georgia case. What's the timeline on those other cases?
Well, I thought the Georgia case, the judge who ruled about whether the information could be released to the public said, I don't want to do that until there is an indictment, because there were indictments that were expected to come as a result of that. But of course, there was a special grand jury that met, and then they had to impanel another regular grand jury. But
they haven't done that yet in Georgia. Fani Willis has not made a decision on whether she's going to convene a regular grand jury to issue criminal indictments in Georgia. Here's the one clue we have about the special counsel. What is he doing? Actions always speak. He keeps compelling everyone at the highest level to testify as soon as possible. This special counsel, Jack Smith, keeps going before the judge and says, I don't care about the privilege argument. Bring him in. We need this testimony. That's a sign he wants to move quickly.
And in that special counsel's case, what were the new developments just this morning happening in Washington?
In the January 6th investigation led by the special counsel and the prosecution keeps gaining ground in terms of bringing in people like Mark Meadows, the former White House chief of staff, John Ratcliffe, the former director of national intelligence, Robert O'Brien, the former national security advisor. Those are not just political advisors. You have the special counsel looking at the national security apparatus and getting a judge to agree with the special counsel's position as they move toward possible prosecution, that we need to hear from these people as soon as possible.
I want to go now to Scott McFarlane, who witnessed the first part of this hearing that Donald Trump inside this courtroom, where criminal charges were read against him. Scott, recap what you saw inside.
Let's underscore the significance of the fact that a former president of the United States now has an official case number in the criminal court system. He is case number 71543-23, according to the Manhattan court system. That's his indictment number. The clerk of the judge, Judge Juan Marchand, read out this indictment, that it was 34 counts of falsifying business records in the first degree. Immediately, Donald Trump was asked how he pleads to that charge. Now, as is past practice in this courthouse, a defense attorney could do that, or the defendant could do that. Donald Trump chose to do that and said, not guilty. This proceeding has so much more to unfold still. There are going to be some references, we expect, to whatever connection the falsified business records might have to other alleged misconduct by the former president. There may be a request for a gag order in this case. And I'll note, it's been nearly an hour now. Donald Trump's been in that courtroom. We'll find out likely soon whether such a motion was made. They're also going to have to get some scheduling matters taken care of. When does this happen next? When does Donald Trump return here, if he has to return for a next proceeding in this case? But a lot of what started off this set of proceedings today, back and forth between an attorney for 20 media organizations and the judge about opening this thing up to cameras, to cell phones in the courtroom, to laptops in the courtroom, to moving media members to different spots in the courtroom so they get a better look at Donald Trump's face. All of those requests were rejected for now. But Nora, the judge in this case here in Manhattan, says he might revisit those rulings the next time they convene in this criminal case.
How did Donald Trump appear to you?
It was noteworthy that he walked in slowly, sat with nothing in his hands. So often when you go watch a criminal case in person, Nora, the defendant's got a pen and paper. The defense has something to make note of what's happening on this day, this most important day of his or her life. Donald Trump had nothing in his hands. They were folded in his lap. He was kind of slumped over at the low-level desk. There was a red velvet rope, kind of like you'd see at a museum to keep you away from the fine arts and the fine exhibits, that separated the defense table and prosecution's table from the audience, from those in the gallery. But I got to tell you, it was a really relatively small courtroom. Big by the standards of the Manhattan courthouse, but small in general. I counted about 20 or 30 people as spectators in that room. There was an adjacent overflow room with another 10 or 20 of us, and we were a little more liberated to leave the courtroom before the proceedings ended. Those in the courtroom are fixed there, likely by Secret Service request or security request, until all of this is over.
When you talked about that red velvet rope, it reminded me of the most recent pictures of Donald Trump at his own club in Mar-a-Lago, where he sits in the middle of the dining room and ropes himself off from other members of his own club while he's having dinner on a Saturday night in an unusual sort of circumstance. Robert?
Just an additional note, when you look at that picture right now, the person at the end of the row is a Trump advisor and lawyer named Boris Epshteyn. And he is someone who has become a confidant of the former president. He's close to the Trump family, close to the Trump sons in particular. He's also quite notable to be sitting there at the table with the former president at this critical moment, legally and politically, because
it's raising some eyebrows.
Well, it's raising eyebrows because his phone, Boris Epstein's phone, was seized by federal agents as part of the January 6th investigation. Who is Boris Epshteyn, if you haven't been following every day? Well, he's someone who was very close to Rudy Giuliani for a long time. And when Giuliani was right there with Trump after November 2020, working to try to overturn the election, who was at Giuliani's side? Boris Epshteyn. So Giuliani was Trump's right-hand man in that post and pre-January 6th period, and Boris was that to Rudy.
I understand that Epstein is also represented by Todd Blanche, who is now part of this.
And part of how Todd Blanche, we're told, was brought into the legal team is because he's friendly with Boris Epshteyn, friendly and representing him.
And Boris actually also goes back to the Russia investigation, which is where we first met him, is in connection with the Russia investigation. He was also under scrutiny, not accused of anything officially, wasn't facing any charges, but he was sort of in that orbit that people investigating were looking at.
I want to bring in our senior investigative correspondent, Catherine Herridge, who has been talking to her sources. Catherine.
Thank you, Nora. Heading into the arraignment this week, one of the Trump attorneys, James Trusty, he's representing the former president in the classified documents case. He told CBS News that the legal team anticipated that there may be what they described as a fatal flaw in the charges that would be brought today. And they were focused on what we've heard Nikki talk about and others, this intent to defraud. Trusty made the point to CBS News that intent to defraud must show more than just an intent to deceive. It must also show that there was an intent to deny an individual or individuals of properties or financial assets. And they think that will be a very stiff climb in this case. Trusty, as I mentioned, is also part of the Mar-a-Lago classified documents case. And he pointed to the fact that other attorneys in that case have been present before the grand jury for the special counsel, and most notably Tim Parlatore. Parlatore told me personally that when he went to the grand jury in December, that he felt his testimony to the grand jury was unexpected and unhelpful, his words, to the special counsel, because he argued that his actions and the actions of the former president did not show a willfulness to retain the records, rather what he described as a willingness to provide back the records once they had been identified. So you can see from the scope of the reporting that it's very broad disagreement as to the strength of the special counsel investigation. Now the Trump people say they don't think it's building to an outcome that would be undesirable to them. But as we just heard from Bob and others, they have a very different perspective on that investigation.
Catherine, thank you. I want to bring in our lawyers and former prosecutors who are with us because these 34 counts, these felonies, center around falsifying business records in the first degree. I'm actually looking at the state code right now, and a person is guilty of falsifying business records in the first degree when he commits the crime of falsifying business records in the second degree, and when his intent to defraud includes an intent to commit another crime or to aid or conceal the commission thereof. Might have to listen to it slowly, but I want to explain it because, again, this has come up multiple times. Why is a hush money payment to a person that he is alleged to have had an affair with, why is that illegal? What is it that they have indicted him on? What is it that they have been able to prove that the Trump legal team is going to try to dismiss and try and win over?
Well, you're dealing with the last clause, which is it's concealment of a crime. And what you have here, it's not only Donald Trump who has, over the years, allegedly paid hush money to people to keep his sexual trysts secret. And that's perfectly legal. You can do that. You sign an agreement with someone, you have a non-disclosure, you're fine. But as always, it's the cover-up that becomes worse than the crime. So here, what the essence of these charges really looks to is the business records themselves, which were a scheme that had, allegedly, the payment to repay Michael Cohen classified as a business expense for legal fees. Michael Cohen paid Stormy Daniels $130,000 because he took out a home equity loan. He wanted the money back.
Mm-hmm. On this very point, if people are saying, well, is this a novel thing that what Donald Trump was doing? Is this something different? I was reading in, and according to the New York Times, the false business records charge is the bread and butter of the district attorney's office white-collar practice, and that since Bragg took office in 2022, prosecutors have filed 117 felony counts of the charge against 29 individuals and companies. So the bread and butter, meaning they do this.
Yes.
This is something that people do.
It's not unusual. However, it's unusual to combine it with a federal campaign violation if, in fact, that's what's there. We still haven't seen it.
And that's what makes it the felony charge.
Correct.
Want to bring in Jerry on that point, because explain for viewers the legal charge, the legal basis behind what they're bringing against Donald Trump.
Well, if we're right in trying to analyze this indictment, which we haven't seen, the payment to Stormy Daniels, if it was done in furtherance of the campaign to quiet her down, to make sure that she didn't speak so it didn't harm his campaign, that really is can be characterized as an in-kind contribution to his campaign, but he didn't report it as such. And not only that, but it wasn't in the true name of the source. Cohen paid the money, but Trump paid Cohen back. So you have those two election law violations, state election law violations. And what's novel here, as you said, is combining the false records with a campaign violation, an election law violation. You know, I think Ricky is probably almost 100% right that he will fight this and never give in, never plea. But, you know, Trump University.
Okay.
You have to watch the former president right now?
That's right.
Okay.
We just saw him exit the courtroom after what appears to be an almost hour-long appearance, because he entered at about 2:30. As I noted, we have had a reporter inside, Graham Cates, inside that courtroom, witnessing everything that we saw, as well as that will add to the details that we already heard from Scott McFarland. This was supposed to be a quick hearing. At least that's what we heard. It was going to be like 20 minutes. Lasted an hour. It's a specific and important case, no doubt. And we're all anxious to hear details of what happened inside.
And what's in the actual indictment. I mean, we finally...
Checking the email right now.
Yeah, exactly.
I'm looking. I'm
While
refreshing.
you check, can I ask a question of Ricky, which is, barring some theatrics is there a reason that it would take that long just on the indictment itself? Reading it out, or is there some process that would take an hour, or does an hour tell you something?
Well, I think an hour is rather long for an indictment, but we don't know what happened in terms of scheduling. We don't know if there were arguments about any other kinds of motions. We really don't know until we find out from people who were in that courtroom. An hour is long for an arraignment. They usually take about 10, 15 minutes tops. And then the judge says, and the next date that you will be here for a status hearing is February, March, whatever it may happen to be, and I'm using past months intentionally, that it should not have taken this long. So something happened in there, and we'll find out what it was.
Ricky, play this out for us as a lawyer. Let's say this first-time offender, Donald Trump, is ultimately convicted of this crime, of these 34 charges. What kind of prison sentence, if any, could they face? What kind of penalty could Trump have in his future if he's ultimately convicted?
He's facing a he's facing a discretionary 4 years in prison, because these are 34 counts, we are told, but they don't stack them one on top of another because it's all part of one scheme. So it would be looked at really, in essence, as one factor, and so you would have a 4-year penalty. Do I expect that Donald Trump is going to prison on this particular case? Should he be convicted of a jury of his peers where 12 people believe the evidence beyond a reasonable doubt? No, I do not expect him to go to prison.
That word you use, discretionary. Who has the discretion?
The judge, 100%. It is in any case, both sides will argue. The judge decides.
And we now see Donald Trump in the motorcade leaving the Manhattan courthouse after pleading not guilty to 34 felony counts of falsifying business records. We have new details coming in right now about what happened inside the courtroom. Let's bring in Scott McFarland. Scott?
Nora, Donald Trump spent exactly 1 hour inside that courtroom for departing. He arrived at 2:25 p.m. Eastern Time, departing here 3:25 p.m. Eastern Time. I can tell you from the part of this proceeding we saw, the overwhelming majority of this proceeding was not the reading of the charges. It was not the arraignment. There was some litigation about opening these proceedings up to media, and there were some number of arguments or discussions after the reading of the charges. We're about to find out what those included. Is there a possibility there was an argument over a possible gag order? Sure, that's been talked about in recent days. We do know, as Donald Trump exited, he did not address the cameras that were there, in which some people predicted he might speak to. So we're going to find out in the coming minutes what else was included in this hour-long hearing. The arraignment, the actual filing of these 34 charges, took just moments. It's a lot still to find out.
Scott McFarland, thank you. We do expect that Donald Trump's motorcade will head straight to LaGuardia Airport, where his red, white, and blue plane with his name emblazoned on it in gold will depart back for Palm Beach and to his private club, Mar-a-Lago, where he is expected to speak tonight. He was expected, according to one advisor, to perhaps address the cameras while inside the courtroom, but he did not. And we'll learn probably why, but he looked stone-faced, I guess is the best way to describe it, while entering and exiting the courtroom.
As we wait to find out the details of this, something when Ricky was talking struck me. If there are 34 counts and they are associated with these checks, we shouldn't forget that there has been reporting, or there's been the suggestion that some of these checks were written while he was president of the United States. And that will be something to look for. So in other words, it may be the same check, but the dates on the checks will be, at least politically, quite significant if some of those dates, some of those checks in this allegations or in this indictment were while he was president of the United States.
Well, again, it's the collision, if you will, of the political world and the legal world. That is a factor that could be very important in the future in the political world. It's not a factor that I expect it has any relevance in Alvin Bragg's indictment. So what we're looking at here are, as they used to say, just the facts, ma'am, just the facts. And the facts here are very straightforward. It's the law that is not. But politically, John, depending on what happens in the future, when we deal with the 2024 elections, the fact that he may have signed these checks while he was president of the United States does create a very interesting wrinkle.
What does it create a new legal wrinkle?
Well, it doesn't create necessarily a new legal wrinkle, but it certainly might give fuel to the fire if someone is looking at a future of saying, well, we can't have him be president, and how do you wind up getting rid of someone who might become president? You have to impeach them. So private conduct doesn't really get us to that level, but conduct while you were president of the United States just might. But that's so far in the future that it takes us away from the present day.
I've been texting with advisors and associates of Trump, asking if they're surprised Trump didn't speak to reporters outside the courtroom. And they said no. They said Trump is a Florida resident now in every sense, politically, culturally. He doesn't like what New York has become for him, the experience of him being in New York, a fortified Trump Tower. He can't go to the 21 Club down the street anymore and have a bite to eat and be greeted by people in the streets. It's a different New York for Donald Trump, and he was given a bracing reminder of that today in Lower Manhattan.
In fact, even when it's hot in the summer in Florida, Trump does not come back. He goes out to Bedford, New Jersey.
Bedminster, New Jersey.
Bedminster, New Jersey, different place than Bedford, New York, and spends his summers out there.
He's going back to his plane, the Boeing 757 now, often parked at LaGuardia Airport. That has long been the place he flies in and out of. This campaign plane was shuttered for a long time, but it has been now put back on the campaign trail for Trump. He's been using it at recent rallies. He'll be flying back to Florida in that aircraft before he goes on to Mar-a-Lago.
And I wonder, as they drive up Manhattan and through the city, if he's reminiscing a little bit. A lot of the buildings that he is passing used to have his name on them. And now those names have been taken down. So the city has changed a lot since he became president in terms of how it relates to Donald Trump.
We've noted that Trump first faced criminal investigations in the 1970s. He has avoided criminal charges up until today as a former president of the United States. But while under investigation and while challenged throughout his life, Trump has used two main tactics: attack and delay. He has been on the attack since this morning. His sons are on the attack as they are personally going after the district attorney and the judge in this case. There will not be a gag order, we believe, in this case. It would be difficult to enforce, as Ricky Kleeman has noted. How does this play out?
And who joins the attack? If you are, there's the 2024 candidates, but anybody engaged in public life, because this is an attack on the judicial system. You attack it for the purposes of undermining whatever finally happens to the president. So who chooses to join in that attack? And there's a cost to doing so, because you're basically saying this is an illegitimate proceeding. That's a very dangerous thing to say.
And on the legal side, delay, 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 which is always the defense point of view. The prosecutor wants to go forward quickly as possible. They want to get this done. And the defense always wants to delay, because delay always benefits every criminal defendant.
You think back to Michael Cohen is at the center of this case, but when I was watching those images come in of Donald Trump sitting there in the courtroom, I was thinking not of Michael Cohen, but of Roy Cohn, Trump's longtime advisor, now passed, but someone who was of New York, of the legal community, highly controversial for his ethical decisions over the course of his career. I was thinking about Roger Stone. I mean, there was a combative advisor and lawyer almost always at Trump's side. He had a few of them today, but it's an entirely different context, a different stage of his life, running again for the presidency. And he's not now the man on page 6. He's a former president of the United States of America, coming back to Manhattan.
And now launching another bid for the presidency, which you have noted will largely become part of his grievance campaign, as he will use that as a means to run for president.
And who's watching this? Who's watching this in the Republican Party? Florida Governor Ron DeSantis, Governor Youngkin, maybe a rising member of the United States Senate, and wonder, is this a moment of political vulnerability, not just legal vulnerability?
And what do you think?
My reporting shows that every Republican who's ambitious is watching this and waiting. And they're waiting to see if the hammer ever drops from that mute figure in American life who has a lot of influence, Jack Smith, the special counsel. If that ever comes down on conspiracy to obstruct, conspiracy to try to overturn an election, those types of federal crimes, Republican strategists tell us behind the scenes, could be the opening, not New York, not Stormy Daniels, at least at this time.
The indictment against Donald Trump has been unsealed, but it has still not been made public. We have had a reporter inside that courtroom. We are going to hear from him shortly. The indictment, what we do know is that the indictment said there was a scheme to pay people off that began in 2015, and Trump himself saying loudly, not guilty. We're also told that he answered a few other questions. More details just coming in. We will bring them to you as we know them. Let's talk about what's next for Donald Trump. He speaks tonight at Mar-a-Lago. What will the effect be of that? What does the former president hope to achieve? What do his political advisors say they want to happen?
Behind the scenes, we're told that Trump is actively making fun of Florida Governor Ron DeSantis because he's watching all this tape come in of DeSantis on the campaign trail. DeSantis hasn't announced anything, but moving closer to a bid. And Trump is telling his advisors, they're scared of me. They don't want to take me on. So what we expect to see in the speech tonight is for Trump to cast Alvin Bragg, the district attorney, in a negative light, but also be defiant and express confidence about his own presidential bid.
And there we are watching the motorcade of Donald Trump make its way up what looks like the FDR on their way back to LaGuardia, where he will fly. We just have the indictment being handed to us. Let's bring in Scott McFarland. Scott.
I'm joined here by Graham Cates, who was in the courtroom. I was in the overflow courtroom. You mentioned that Donald Trump spoke 6 times. What were the other 5 things he said besides not guilty?
That's correct. The judge ran through with him some of his rights. He has a right to a different attorney if he wants to. He also can waive his ability to appear at different hearings, either voluntarily, depending on some factors, or if the judge is unhappy with his behavior, essentially. And each time the judge gave one of these instructions, he asked former President Trump, do you understand? And Trump said, yes, or I do, yes, or I do. And this happened 5 times. And then the other time he spoke was when he said, not guilty.
What's important to underscore here is that there was no gag order issued in this case. There were a lot of pieces of speculation that they may order the parties to be gagged on this because there's been such fiery rhetoric coming from the former president. No reference to a gag order, no proposed gag order.
That's correct. What they're working out right now, though, is a deal about discovery where they're going to limit how much he and the defense team and the district attorney can talk about the things that are produced by the prosecutors to the defense team. There was some discussion of maybe only meeting in one room with the defense team and him not being allowed to take materials out of that room and him being barred from sharing it with anyone, including the press.
What the court clerk said as she read this charge was 34 counts of falsifying business records in the first degree. Later in the proceedings, there was also a reference from the state, from the district attorney, to a scheme.
That's right. They said that their investigation dates back to materials that go as far back as 2015, where they described former President Trump and a former lawyer who we know to be Michael Cohen discussing the ability to pay off people so that material that might hurt his presidential campaign wouldn't make it into the fold.
I would say this, Nora. This is such a humble building compared to the other courthouses across America, the federal courthouses, the Supreme Court. Kind of small, a little stuffy, a bit of a dank room. I noticed the former president smiled slightly when the press photographers were in the room for a few moments. Otherwise, kind of hunched over in his chair, somewhat expressionless, nothing in his hands, no pen, no paper, no note-taking. And it was his defense attorney, Tom Blanche, the newly hired defense attorney, who spoke for him.
That's correct. Todd Blanche. So he was very serious. Donald Trump was very serious. He didn't make a lot of gestures. He whispered with his attorneys a little bit. But Blanche kind of said, we need to see this indictment. Now that it's finally unsealed, we need to study it and then figure out what our next steps are. Nora.
Graham, I'm just looking at a press release from the Manhattan District Attorney's Office that is a statement of fact that the defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. I want to walk through this with you. They first note that in one instance, American Media, Inc., AMI, which is the holding company for the National Enquirer, paid $30,000 to a former Trump Tower doorman who claimed to have a story about a child Trump had out of wedlock. How does that factor into this?
You know, in court, they didn't describe one by one what the different allegations were, other than to lay out this timeline that I think went back further than we expected. And that's actually the first time hearing about it. So I think we're going to see that there are other materials. We've known so much that has come from people like Michael Cohen and others who are kind of in this orbit. But now with these investigators who have been looking into this since actually about 2018 are finally revealing to us what they've learned in all that time.
And Graham, correct, there was no gag order issued by the judge, but there was a warning about social media posts.
That's correct. You know, he asked both the defense attorneys and the prosecutors to talk to the defendant, former President Donald Trump, and their witnesses about making any comments that he said could incite violence or unrest. I mean, he gave a few different instructions along those lines, saying you should really tell your client not to make social media posts that might incite violence, not to say things that might incite violence. And this was after the prosecutors handed him a list of social media posts, they said, that they believed made this area around the courthouse one that needed even more securing than it would have been normally if a former president was coming around.
What's more, this is the first, but it also might be the last proceeding in which the media is blocked. The permission to use cameras, the permission to use laptops or phones inside the courtroom. The judge said he'd consider opening it up for future proceedings. So this might be a one-of-a-kind moment where everything's happening behind closed doors and a closed curtain.
Graham, I want to also continue to read from this press release from the Manhattan District Attorney's Office about this concealing criminal conduct from the public during the 26th presidential election. The first instance that I mentioned, according to this press release, that AMI paid $30,000 to a former Trump Tower doorman who said they had information about a child that Trump had out of wedlock. In a second instance, according to the press release, AMI paid $150,000 to a woman who alleged she had a sexual relationship with Trump. And when Trump explicitly directed a lawyer who then worked for the Trump organization to reimburse AMI in cash, the special counsel indicated to Trump that the payment should be made via a shell company and not by cash. What does this tell us in terms of what you heard in that courtroom?
That was really important. You know, it's not about the payments themselves. It's about the falsification of business records. So the attempt to cover up, allegedly, who the payment came from and who the payment was to. And again, they stress that this was, according to them, done so that it would make his campaign one that where this wasn't causing stumbles and it wasn't becoming a bigger issue for him, all of these different instances.
Let's bring in former Manhattan District Attorney Cy Vance, who first opened the investigation into former President Donald Trump in 2018, but left office before those charges were filed. This is his first interview since the indictment has been unsealed. Mr. Vance, thank you for joining us. First, since you have knowledge of much of the information against Donald Trump, your reaction to these 34 felony counts?
Well, first, Nora, my reaction is to the proceedings themselves. I think your excellent panel has all talked about the sobering nature of the proceeding. And I think, first of all, we should all take heart in the fact that the proceedings went off in an organized, calm and deliberative manner. I think many thought that when this arraignment would take place, it would precipitate violence outside the courtroom or near the district attorney's office. And at least as of this point, that has not happened. And that is good. I think it is a harbinger of how Judge Merchan is going to want to run this case. He's going to want to keep it on a tight schedule. He's going to want to control the conduct of the party so that they do not have this proceeding go off track. And I think, as should be the case, I have hope that this will proceed in a way where the public will find out the relevant information at the trial, and a judgment will be rendered at the appropriate time by a Manhattan jury.
Do you think that Donald Trump will be found guilty?
I don't have the evidence. I've gone through the indictment very quickly, and so that would be premature and I think inappropriate for me to answer that question, not knowing so many of the facts that are particularly known by the Manhattan District Attorney's Office. I will say that they've spent a lot of time on this, and I think they have obviously believed that they put together a solid case, or they wouldn't have brought it. But the actual merits in a case like this go through a lot of checkpoints where facts need to be proved, theories need to be tested, and your excellent panelists have discussed many of those factors that are going to unfold in the coming months.
Mr. Vance, I know that you originally greenlit this investigation. You brought on Mark Pomerantz, who's written a book about this, but ultimately you left office before any charges were brought, an indictment, and it took Alvin Bragg to move this forward. What happened in that time? Why was Alvin Bragg able to bring an indictment that you were not? What pieces of the investigative puzzle were added, do you believe?
Well, first of all, Nora, I think there's a slightly more nuanced background. We did indict in the summer of 2021 the Trump Organization in 17 counts for a broad tax fraud conspiracy, along with its chief financial officer, Alan Weisselberg. We first started down this road in probably 2017 neighborhood, and we're investigating when the federal government commenced its investigation into the hush money payments, and that the office asked our office to stand down on our investigation. And I said yes. I thought it was appropriate out of my respect for the U.S. Attorney's Office and their experience. But I was surprised when, after Michael Cohen pled guilty, that the case seemed to have been dropped by the federal government. We had turned our attention onto financial investigations of the Trump Organization and former president. I can say that without breaching confidence because I was sued by the president and the office. And in that lawsuit in federal court, he attached a copy of our grand jury subpoena, which typically is something that cannot be revealed unless you're the person receiving it. So for the next period of time, we were investigating financial matters as outlined in the grand jury subpoena. But what happened, of course, Nora, is COVID. And COVID was obviously very impactful on our ability to get a grand jury, to compel evidence, to compel production of documents. And we and New York City and all over the country, we were really unable to move in using the traditional investigative techniques during that long time period. But we continued to press ahead, and actually in that time period, that other year and a half, went to the Supreme Court twice, through 2 district courts, through 2 separate panels of courts of appeal, and a full hearing before the Supreme Court. And ultimately, the Supreme Court issued its ruling, first, that no man or former president was against being investigated, and secondly, that Mr. Trump and the organization had to produce this document. So when you say we didn't move forward, I just want to be clear that there was a lot of work done that leads up to this day in earlier chapters. But in truth, in the summer of 2021, as my term was expiring, we did not have the time to complete the investigation, the broader financial investigation that was underway. And ultimately, whatever decisions I made about going forward or not, I understood it was going to be the new district attorney's decision on what to focus on. And you see, since he came in office, this has been his focus.
And Mr. Vance, thank you very much for that clarification. It was your work that ultimately led the Supreme Court to deny Trump's final bid to block his tax returns that were ultimately turned over in what was a huge case that we covered, certainly from Washington when the Supreme Court made that. So thank you for pointing that out, the work of your office and the prosecutors there. I want to ask you about the legal theory behind the current district attorney's case, which is essentially elevating these misdemeanors to a felony charge by linking them to a campaign finance violation. Is that a difficult case to prove?
Well, I think my experience, as you have very ably, you and John have very ably explained with your panelists, a false business records charge is not new to the district attorney's office. It's sort of the equivalent of a conspiracy charge in federal court. So those are charged all the time. During my tenure, we did elevate a misdemeanor false business record charge to a felony when it pertained to other crimes that were intended for the creation of the false business record, including some federal crimes. But what was not done during our office was to elevate it for purposes of proving that the false business record was designed to violate federal election laws. That's something that was not done by my office. I'm not sure it has done by the office. That does not mean it is legally deficient, but I think, as others have said, this will be one of the early test points that the defense will bring, presumably an early motion to dismiss, to take on that theory and to ask the court to rule that these counts cannot be elevated and therefore should remain as misdemeanors. Now, as Jerry Goldfeder said, the objects of the false business records in some instances may be violations of state election law. That's going to be, again, another focused effort by the defense to figure what happened there. At the end of the day, Judge Merchan is going to, I think, early on, or within a reasonable period of time, issue legal rulings on these fundamental preliminary law issues, and I think that's where we'll see the first efforts of the defense.
Thank you, Mr. Vance. And John Dickerson is here as well.
My question, Mr. Vance, hi, is in what we have before us, it talks about how the defendant, Donald J. Trump, orchestrated a scheme from August 2015 to December 2017. And before we've had this information, we've mostly been talking about the hush money payments to Stormy Daniels. What appears to be the case here, and my question to you is this a narrative technique or is this a legal argument, which is essentially, it seems to be arguing that Donald Trump started a conspiracy in 2015 that was this entire catch and kill, and that the entire catch and kill idea was a campaign violation, that it was orchestrated from its... Yeah, go ahead.
I apologize for interrupting you. I obviously haven't had time, nor have you, to scrutinize the indictment. In my quick pass-through, I didn't see a conspiracy count. Maybe there is one. And if there is, please tell me. But you're talking about essentially sort of what we call a speaking indictment, which is an indictment that provides just more than bare-bone facts, but that also provides some explanation of the underlying conduct, which is used as a public document to explain to the public the underlying bases for the charges. What I principally saw was false business record counts. And it looks like there are several different time periods involving different people where it was done, one with the doorman, one perhaps with Karen McDougal, and another one with Stormy Daniels. That's what I see as the gravamen of the charges. But it is a story, and it's just cases are tried as stories. And I think the story that will be put forth here is a multiple-year conspiracy to violate state and election laws by manipulating the internal books, ledgers, checks of the company.
Michael Cohen's potential testimony, how would it factor into this case in the coming months?
Mr. Cohen obviously is going to be attacked very heavily by the defense. They will paint him as a liar and unbelievable. But as I've said before, and as someone who has tried many, many, many cases with individuals who have criminal records as principal witnesses for the prosecution, you take your witnesses where you find them. And the question really will be, what is the quality of the corroborative evidence outside of Michael Cohen's say-so that a jury can rely upon to believe Michael Cohen when he says something happened? So the quality of the corroborative evidence will be key. Now, if we have false ledgers and checks and the like, and Mr. Cohen can tie those tightly with his behavior. That will, in some sense, bolster Mr. Cohen's credibility, even though it will be heavily attacked. And finally and foremost, he worked for Donald Trump. And so while one can say whatever you want to say, there was a proximity between himself and Mr. Trump and a closeness, which I think will be a factor the jury will consider as it looks at Mr. Trump's credibility. Mr. Cohen's credibility.
Former Manhattan District Attorney Cyrus Vance Jr. Mr. Vance, thank you so much. We appreciate it.
Thank you so much.
And we want to show you what is a shot of a press conference where we are expected to hear from the current Manhattan District Attorney, Alvin Bragg, who will speak shortly about this historic indictment. Want to bring back in Scott McFarlane and Graham Cates. And I understand dates were decided on for the next hearings and even a trial. What can you tell us?
Yeah, Nora, the next court date, the next court proceeding scheduled in this criminal case is for December 2023 with a tentative trial date of January 2024. But to put it charitably and mildly, all of that is subject to change. Everything remarkably fluid at this stage. But I also want to bring in Graham for this. There was a reference during the proceedings to that social media post Trump made showing himself with a bat and the district attorney, Alvin Bragg. Why did that come up?
The prosecutors put forward to the judge a set of documents that they said was a printout of several social media posts that former President Trump had made. They specifically highlighted the one with the baseball bat. And then they said that they were seriously concerned about public statements threatening our office, the court, and the city of New York. And they said that some of the statements directly addressed the grand jury and intimidated witnesses. And they asked the judge to address that. Now, Trump's attorney, Todd Blanche, said it is true that Trump was responding forcefully, he said, but he said this was because witnesses who had spoken out about appearing before the grand jury, and even he said the DA's own leaks, which they kept referring to, had pushed Trump into a place where he felt he had to respond aggressively. Now, I want to point out that on this, the judge, Juan Marchand, actually did speak about this, and he said it didn't look like to him like this was just responding to that, but that he thought that some of this rhetoric was too much. But he said he wasn't issuing a gag order at this point anyway.
And I'll note, no gag order issued, which means that will not impact the former president's expected remarks tonight in Florida.
There was one thing about the gag order, which is that the judge said one of the reasons he's not doing it is because this is a presidential candidate and he's aware of the First Amendment considerations in attempting to limit the speech of someone who is running for president. Nora.
From Graham Cates and Scott McFarlane, who witnessed this historic hearing today. Thank you. Also want to recap that Donald Trump pleading not guilty to 34 counts against him of falsifying business records in order to conceal other conduct. That's why they were felony charges. From a press release from the Manhattan DA, we learned about 3 particular instances that they have zeroed in on. That AMI, which is the parent company for National Enquirer, paid $30,000 to a former Trump Tower doorman who claimed to have a story about a child that Trump had out of wedlock. In a second instance, AMI paying $150,000 to a woman who alleged that she had a sexual relationship with Trump, and that then the special counsel was asked to make a payment via a shell company and not cash. And then in a third instance, 12 days before the presidential general election, the special counsel wired $130,000 to an attorney for an adult film actress. That is the Michael Cohen and Stormy Daniels case that has been discussed ad nauseum by many about what is the heart of this case. But there were others as well that have been mentioned today. Ricky, you've had a chance to look through this indictment. What stood out to you?
Well, we have to look at the indictment, and the indictment doesn't tell us much more than what the charges are. But the district attorney, Alvin Bragg, has filed a statement of facts. And it's the statement of facts, which is 13 pages, that really is, in essence, the talking indictment. It becomes a substitute. And what we learned, or at least what I learned in my quick read, is that the story that has to do with Stormy Daniels, the story that has to do with Karen McDougal, 2 women who had sexual relationships with Donald Trump, a story involving a woman and a doorman about her story. None of this is new for those of us who have followed Donald Trump's activities. But what we learn out of this is one witness, obviously, Michael Cohen. Second witness, clearly David Pecker, the head of American Media, the National Enquirer, where they were given a non-prosecution agreement. But very interesting to me is when we get down to about paragraph 26, we have the Trump Organization CFO, and then we get to the controller, and then we get from Trump Organization, and then we even get to the accounts payable supervisor. So my assumption...
What does that mean to you?
What it means to me is that these people have testified before the grand jury or have given statements to the district attorney's office, and these are going to be the witnesses. So the real wild card here is, where is Alan Weisselberg right now? Alan Weisselberg is in Rikers Island. He is serving a prison sentence.
He's the CFO, the former CFO.
He is this former CFO, and he is clearly, on this statement of facts, a linchpin in creating this so-called scheme of the falsification of the business records. He's critical.
That is the missing piece of the puzzle in many ways that we were waiting. What brought them to this very moment? I do want to bring in now, because we have just heard from, as we watch Trump boarding his plane back, we'll split screen this now, because we've just heard from Trump's attorneys, Joe Tacopina, and for the first time, Todd Blanche. Let's listen.
There's not really any surprises. I know there was a lot of talk over the past several weeks and the past several days about what's going to be in this indictment and what's going to be there that we don't know. There must be something besides what we've been talking about for the past 4 or 5 years. There's nothing. The indictment itself is boilerplate. It doesn't allege any federal crime, any state crime that's been violated. It doesn't allege what the false statement is. And it's really disappointing. It's sad, and we're going to fight it.
Can you tell us what Mr. Trump's reaction was?
Were you surprised by anything in the indictment?
No.
How about you, Joe? Were you surprised?
I was surprised there were no facts in there. I mean, normally in an indictment you have alleged facts. So they said that this was a false business record entry to aid and abet another crime without saying what the other crime was.
Can you tell us what Mr. Trump's reaction was when he saw the charges against him?
When you say what his reaction was, what do you expect his reaction is? I mean, his reaction is exactly what would happen if it happened to anybody that I'm looking at now or anybody that's hearing what you're saying. He's frustrated, he's upset, but I'll tell you what, he's motivated. And it's not going to stop him. It's not going to slow him down. And it's exactly what he expected. And so to that extent, there's no surprise. But he's also upset and frustrated and disappointed and mad that this happened.
What about the warnings against his rhetoric on Twitter? What was the former president's reaction?
It was not a warning. What do you mean?
From the judge, talking about
the threats to the Manhattan
DA.
The district attorney made a statement addressing what they perceive to be, I'm not sure what the words they use, inappropriate rhetoric of some sort. Obviously, we responded, and the judge just took it in. The judge didn't warn. He asked the parties to consider what they're saying and not saying.
Guys, he did not admonish the president, and that's important.
He made a request that the president not use language that would incite violence or civil unrest.
He did not request that the president not use language. He requested that everybody involved refrain from using language that's inappropriate. And by the way, that includes the witnesses for the people who were talking just as much as the president.
It also includes the former president swinging a baseball bat at the head of the Manhattan DA.
Well, I don't know where you got that, because if
that was a tweet sent out by the former president.
No, it wasn't. And first of all, that picture was not him swinging a baseball bat. I mean, if you want to distort the facts, go right ahead. I won't address that. Yes, it is. He wasn't swinging a baseball bat at anyone's head. That was a picture of him showing off an American-made bat. Someone else put a picture of the district attorney next to him, and in an article posted that. That's not
Will Mr. Trump commit to not using language that incites
Guys,
any
here's what we're going to talk
type
about
of
today. Here's what
reaction
we're going to
from
talk
his
about today. We're going to talk
supporters?
about
Will he
the
commit to
insufficiency
that?
of this case. And I will say this to you. Today's unsealing of this indictment shows that the rule of law died in this country. Because while everyone is not above the law, no one's below it either. And if this man's name was not Donald J. Trump, there is no scenario we'd all be here today. Please understand that based on these charges.
What are we going to hear from him tonight when he speaks?
When?
Tonight.
Yeah, 8 o'clock.
What are we going to hear
What?
from him?
I don't know. You'll hear it.
The prosecution wanted a trial date for January. Did you think that was realistic?
No. Can you guys talk about, there's a lot of speculation about the unity among the defense attorneys.
Look at this.
There's
Look
a
at
lot
us.
Is that why you chose to do this? To come out
To come out together?
We are, no,
We
that's
chose to come out together so we could speak with one voice, but there is no disunity here. That's gossip and it's nonsense. We've been working together and we will be working together.
And this, to me, quite frankly, is the best team I've ever worked with lawyers. I'm honored to be working with these guys. It's a family, it's a team, and we have one mission, and we'll achieve that.
What's your next move? What's your next move?
My mom wants to know. I'm going to go home and have some food.
What about the appeal the charges? Are you going to appeal the charges?
When do you start filing? When do you start filing motions? I'm assuming one of the first things you're going to do.
The judge set a motion schedule
To dismiss. I assume that'll be something.
The judge set a motion schedule that requires motion filed in 4 months. So that's the motion filed.
This whole notion about how this is sort of like a novel or
It's not a notion. It's actually a fact.
but talk about that. But like,
there's nothing else to say except the district attorney. This office has existed for decades and decades, and you can find one if you like. You'll never see a charge like this ever.
You understand this? You understand this? It's simple as this. A state prosecutor is prosecuting a federal election law violation that doesn't exist according to federal election law officials. It's as simple as that. You could sum it all up like that.
Will there be anything else in the motion?
We haven't even come
what about
close.
the
prosecution is
venue?
worried that
Can
the
someone address
prosecution is worried that the
now?
defendant could potentially post discovery on social media. Will you commit that your client won't do that?
That won't happen.
But
And
what
more than us committing, he's committed.
What
We're not
about-
here like
What
we're
have you
gonna
said
change
to
it.
your
venue.
client about posting on social media? Have you given him any
We're not having
counsel?
any discussion about what we told him.
What
Are you
about the
surprised
change of
the mention
venue?
of two women?
Just answer this question about the change of venue. There's a lot of
It's premature.
right. So why is he talking about that? Why is he trying to move this to a place
So
like Staten
once
Island?
again, we're 3 lawyers here to litigate and fight this case. We're not PR consultants. We're not social media consultants. Donald Trump has made one hell of a brand and became president of the United States with his social media and posts and everything else, his messages. We are here to talk about the case and litigate the case. We can't address what he posts, what he wants to post, or it posts.
But as his attorneys, have you told him to stop posting this rhetoric,
So
these
what I
messages
said
about
before
the
was
judge?
we can't, literally, we can't tell you what we've discussed.
No,
with
I
our
understand,
client.
but
So
are
that's
you
the answer.
concerned that he's continuing to
Not
go
concerned
after
at
the
all.
judge, talking about the judge's wife, talking about the family? I mean, are you?
I don't think
any
the judge
other
was concerned about it.
Yeah, but any other defendant, wouldn't you be like?
Any
"You
other
need to
defendant
stop"?
wouldn't be here
He's
today.
not going after the judge. He is not going after the judge. He commented that he thought that there were some issues that may cause a conflict. That's not going after the judge. He is not threatening
going
the
after
judge.
the
He is
DA.
not going after the
Right,
judge.
he's going after the
He
DA.
has said that the DA, he is angry because the DA has brought a case that is unjustified.
I mean, it
and
wasn't
so
just
I'm
that,
not
but
going
it
to
was
comment
more
on
than
it.
just saying he
You
was
may
angry.
disagree with the
But
way
it
he
was-
spoke.
Can you
but
talk
you
about the
may-
process?
can you
Was
talk
he
about the fact it was
fingerprinted? Was there a
We're not gonna talk
mugshot?
about
Was
it.
there a
In fact,
mugshot?
I think thank you
What
for your
about
attention.
fingerprints?
Were you
What's
surprised
my
that
message?
What is his message to your supporters gathered here?
The 3 members of Trump's legal team addressing reporters and answering questions. If there was any thought that Joe Tacopina had been sidelined from the legal team, he made clear to show that he's not. Once again, displaying his pugnacious style, defending his client. But also we heard from Todd Blanche the first time, who has a record as a criminal defense attorney today, but as a well-known prosecutor, federal prosecutor in the SDNY. And he said Trump is motivated. This is not going to stop him. He's upset. He's frustrated, mad. Those were all adjectives he used. And you heard Donald Trump's legal team dismissing, almost mocking what was in this indictment.
They called it boilerplate. You had 3 lawyers there that are now key members of Trump's legal team, at least on the New York case. Joe Tacopina, Todd Blanche, the new addition, and Susan Necheles. Then they are working together in that media scrum to start to preview what's to come in terms of motions to dismiss, arguing that this case should never have been brought, and pushing back against characterizations of what actually unfolded in that courtroom today.
What struck you about the style of that presentation and the way they answered questions from the media scrum?
Trump always seems to have a tension between those who are in the style of Joe Tacopina and those who are in the style of Todd Blanche. There's always the Steve Bannon alongside the Jared Kushner, the Joe Tacopina with the Todd Blanche, the Mike Pence along with the Roy Cohn. And these are the counter forces he has in his orbit going back 50 years. Not surprising to see them there again today.
Yeah. Ricky Kleeman is someone who has looked through and read through this entire indictment and then heard a quick rebuttal. I mean, this was a press conference, certainly from Trump's attorneys. They seem to feel fairly confident.
Well, if the only thing they looked at was the indictment itself, it is boilerplate. That is a statement of fact. Yeah. What we learn comes...
Because they haven't seen the documents in the discovery.
Well, this capital S statement of capital F facts, which is signed today by Alvin Bragg, appears to be a court filing the way it is written. And that is, in essence, the substitute for the speaking indictment. And this is really detailed.
And as you can see now, we're showing you pictures from inside this room where we're going to hear from the district attorney who will distill for members of the press and the public more details that round out this so-called boilerplate indictment. And I want to bring in Scott Frederickson in just a second, but go ahead.
Well, just for Joe Tacopina to say there were no facts, I mean, they may be wrong. They may be the DA's version of events, but there are facts, lots of them, that were outlined. So that's just not the case.
Well, I don't know, actually, if they had them in their hand, because it came slightly after the indictment itself. But it is filed. I mean, it's got its heading. It has the indictment head. And the reality is it's going to show us what is going to come.
And now let's hear from the Manhattan District Attorney, Alvin Bragg.
Here today. Earlier this afternoon, Donald Trump was arraigned on a New York Supreme Court indictment returned by a Manhattan grand jury on 34 felony counts of falsifying business records in the first degree. Under New York state law, it is a felony to falsify business records with intent to defraud and an intent to conceal another crime. That is exactly what this case is about. 34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are. We cannot and will not normalize serious criminal conduct. The defendant repeatedly made false statements on New York business records. He also caused others to make false statements. The defendant claimed that he was paying Michael Cohen for legal services performed in 2017. This simply was not true. And it was a false statement that the defendant made month after month in 2017. April, May, June, and so on through the rest of the year. For 9 straight months, the defendant held documents in his hand containing this key lie, that he was paying Michael Cohen for legal services performed in 2017. And he personally signed checks for payments to Michael Cohen for each of these 9 months. In total, the grand jury found there were 34 documents with this critical false statement. Why did Donald Trump repeatedly make these false statements? The evidence will show that he did so to cover up crimes relating to the 2016 election. Donald Trump, executives at the publishing company American Media Incorporated, Mr. Cohen, and others agreed in 2015 to a catch and kill scheme. That is, a scheme to buy and suppress negative information to help Mr. Trump's chance of winning the election. As part of this scheme, Donald Trump and others made 3 payments to people who claimed to have negative information about Mr. Trump. To make these payments, They set up shell companies, and they made yet more false statements, including, for example, in AMI, American Media Incorporated's business records. One of the three people that they paid to keep quiet was a woman named Stormy Daniels. Less than 2 weeks before the presidential election, Michael Cohen wired $130,000 to Stormy Daniels' lawyer. That payment was to hide damaging information from the voting public. The participant scheme was illegal. The scheme violated New York election law, which makes it a crime to conspire to promote a candidacy by unlawful means. The $130,000 wire payment exceeded the federal campaign contribution cap, and the false statements in AMI's books violated New York law. That is why Mr. Trump made false statements about his payments to Mr. Cohen. He could not simply say that the payments were a reimbursement for Mr. Cohen's payments to Stormy Daniels. To do so, to make that true statement, would have been to admit a crime. So instead, Mr. Trump said that he was paying Mr. Cohen for fictitious legal services in 2017 to cover up actual crime committed the prior year. And in order to get Michael Cohen his money back, they planned one last false statement. In order to complete the scheme, they planned to mischaracterize the repayments to Mr. Cohen as income to the New York State tax authorities. The conduct I just described and that which was charged by the grand jury is felony criminal conduct in New York State. True and accurate business records are important everywhere, to be sure. They are all the more important in Manhattan, the financial center of the world. That is why we have a history in the Manhattan DA's office of vigorously enforcing white-collar crime. My office, including the talented prosecutors you saw at arraignment earlier today, has charged hundreds of felony falsifying business records. This charge, it can be said, is the bread and butter of our white-collar work. And fraud presents itself in all different forms here in Manhattan. We have charged falsifying business records for those who violated federal bank secrecy laws. We have charged falsifying business records for those who were seeking to cover up sex crimes. And we have brought this charge for those who committed tax violations. At its core, this case today is one with allegations like so many of our white-collar cases. Allegations that someone lied again and again to protect their interests and evade the laws to which we are all held accountable. As this office has done time and time again, we today uphold our solemn responsibility to ensure that everyone stands equal before the law. No amount of money and no amount of power changes that enduring American principle. I'll now take questions.
So we're going to take a limited number of questions. There are no follow-up questions. One question per reporter. I will call on you. And again, we have limited time. Thank you. The first question will be Rick.
Thank you. Ricky, why now? I mean, some argue that this is a political move. You're not going to be a political person. If Rick is going to go into this.
We conducted a thorough and rigorous investigation, as we're known to do, at the Manhattan District Attorney's Office. I've been doing this for 24 years and am no stranger to rigorous, complex investigations. I bring cases when they're ready. Having now conducted a rigorous, thorough investigation, the case was ready to be brought, and it was brought.
Mr. Bragg, the indictment says that there were 34 false business records. And they were done to conceal another crime, but the indictment does not specifically say what those crimes were. We are assuming, perhaps, that they might be election-related. I'm wondering if you can specify what laws were also broken.
All right. So let me say as an initial matter, the indictment doesn't specify that because the law does not so require. In my remarks, I mentioned a couple of laws, which I will highlight again now. The first is New York State election law, which makes it a crime to conspire to promote a candidacy by unlawful means. I further indicated a number of unlawful means, including more additional false statements, including statements that were planned to be made to tax authorities. I also noted the federal election law cap on contribution limits.
But why weren't there those crimes charged? Why wasn't he charged with those crimes?
Well, I'm not going to go into our deliberative process on what was brought. The charges that were brought were the ones that were brought. The evidence in the law is the basis for those decisions.
You had expressed a year ago that you had some reservations about the case's readiness. Can you talk to us about what were some of the questions in your mind that needed to be answered in order to bring a case of this magnitude?
I'm not going to go chapter and verse into any thinking. What I will say is, I believe the time period you're talking about, I've been in office for a couple of months. The investigation, in my view, was not concluded into the conduct in particular that is the basis for the charges today. Since that time, we've had more evidence made available to the office and opportunity to meet with additional witnesses. So as I said earlier, I've been doing this for 24 years. I don't bring cases prior to a thorough and rigorous investigation. Now, having done so, the case has been brought.
Mr. Bragg, Garrett Hake with NBC News. Your predecessor took a hard look at this case and decided not to charge it. Federal prosecutors took a hard look at this case and decided not to charge it. Do you believe you have new evidence that led you to decide to charge this, or why now?
Well, as I just mentioned, we have had available to the office additional evidence that was not in the office's possession prior to my time here. And as to your part of your question about the federal, we have a distinct and strong, I would say profound, independent interest in New York State. This is the business capital of the world. We regularly do cases involving false business statements. The bedrock, in fact, the basis for business integrity and a well-functioning business marketplace is true and accurate record keeping. That's the charge that's brought here, falsifying New York State business records.
Thank you. DA Grant, I'm just going to read back one line from your statement of facts. The participants also took steps that mischaracterized for tax purposes the true nature of payments in furtherance of the scheme. Do you allege former President Trump was one of the participants who mischaracterized the payments for tax purposes?
I'm not going to go beyond the plain language statement of facts, which I think speaks for itself.
Brad, can you please comment on the strength of the evidence that Trump personally intended to violate state election law, including actions that are charged in the indictment?
So the charge is falsifying business records. The charge requires, as I specified, criminal conduct that was concealed. One of the concealed crimes we allege is New York State election law. I sort of went through in our statement of facts, which I think many of you have in front of you, goes through things including, text messages, emails, contemporaneous phone records, multiple witnesses. All of that will be, as you saw in the fall, borne out in a public courtroom in downtown Manhattan.
Last question is Jonah.
Yeah, Greg, the charges related to the hush money payments to Stormy Daniels, the release from your office also mentions another woman, Karen McDougal, as well as a doorman. Can you comment on how those players are related to the charges you've brought or to the case overall?
I'm glad you put your finger on that, because it's not just about one payment. It is 34 business records, 34 false statements in business records, and we're concealing criminal conduct. And the earlier question about New York State election law, when I talked about conspiracy to promote a candidacy by unlawful means. Those unlawful means, we allege, include the conduct set forth in the statement of facts, which is additional false statements, separate and apart from the charged ones in AMI documents, planned false statements to taxing authorities. It is not just that one $130,000 wire payment. Thanks so much.
Mr. Bragg, any comment about any incitement of violence by former president?
At what point do you think that order is necessary?
And we just heard from the Manhattan District Attorney Alvin Bragg outlining what is the new evidence he said that led him to bring this case before a grand jury. And of course, these 34 indictments as the president was arrested, booked, and pled not guilty today. Ricky Kleeman, quickly on that point, not only that he falsified business records, but something else we just heard at the tail end there that could be significant.
Well, because Alvin Bragg is saying that in this conspiracy to promote a candidate by unlawful means, that one of those things was that it affected the tax authorities. So the question was, how did the false statement become a tax violation? Well, it's accounted for as a business record because it's a legal fee, and that was not true.
Let's bring in Scott Frederickson, former prosecutor who's been listening as well. What did you learn from those words by the district attorney and the indictment?
Well, we learned a lot here finally today. This is a powerful indictment. It's no longer just the Stormy Daniels affair and the payoff. It's a scheme. It's a scheme to catch and kill. It's executed by meetings at Trump Tower. There's 3 parties to it. The CEO of American Media, Michael Cohen, and it says 2 of the parties have pled guilty. It describes the shell companies, the payoffs, and it even describes then when in the White House, after having been elected, the pressure campaign to prevent Mr. Cohen from cooperating. So I think you have to hand it to the DA. They put together a powerful statement of evidence that no defense attorney would want to have to defend against. I think the other critical question here is the legal theory still the same? Because now they reference mischaracterization for tax purposes and state election law. Before, we thought it was just the federal election law. Will that carry the day? In the end, the defense still, its best opportunity here will be try to knock this case out on a motion to dismiss. If they have to go to trial against this, there's an explosive list of the meetings, the payoffs, the campaign to pressure, the guilty pleas by those involved in the agreement. That's a scheme they describe. It's a strong case.
All right, let's bring in Jerry Goldfeder, who also looked at this and is a campaign finance lawyer. Jerry, what did you learn?
Well, I think that our speculation over many weeks has been borne out. The false records has been tied to alleged election law violations. And I think if in fact this indictment does survive a motion to dismiss, the jury will see a lot of texts, will see documents, and will hear from multiple witnesses. And I think reading the facts as presented by the district attorney, it's not going to just be Michael Cohen. It's going to be a variety of people. And the question will be for the jury as to whether or not District Attorney Bragg will be able to prove by beyond a reasonable doubt whether or not all these facts constitute activity that's in furtherance of his presidential election. He's going to defend himself and say it's not, but we're going to have a tremendous number of documents, and we're going to have testimony to tie this business records charge to the presidential campaign. That's what makes it a felony.
Jerry Goldfeder, thank you. And Jeff Pegues, some of the criticism made by Trump's team has been you can't base a whole case on Michael Cohen. You know, he's a felon. He's served time. That's not going to hold up. But we learned there are additional witnesses, new evidence, and in the words of some here, this is a powerful indictment.
Yeah, I think what they've done is bolster their case with this witness testimony. Alan Weisselberg must have said something. right? We
don't know yet.
Well, we don't know yet, but I think this is where this is heading. That may have been some of the evidence they have, in addition to what they have earlier, that really helped bolster this case. Because you're right, Michael Cohen, who was an insider, who was really close and loyal to Donald Trump.
The fixer.
He was the fixer, the special counsel title that he loved so much. I've talked to him about that over the years. But he does have credibility problems, right? So you have Alan Weisselberg. He's a guy that doesn't talk, right? He is...
The vault.
He's the vault. You know, back in the day when they prosecuted mob cases, they would have the accountant who wrote everything down, didn't say anything. You know, so for the Trump organization, Alan Weisselberg is the key. And if you look at all those people, Cohen, Weisselberg, Pecker, they have all suffered consequences as a result of crimes or alleged crimes related to all of this. So if they're going to point up at the big man when they go in front of a jury, I mean, what is a jury to think? Listen, he went down for this, he went down for this. Well, what about the guy that they were all doing it for?
When you look at this statement of fact, there's another piece of history here. So much of the facts detailed come in the first year and second year of Trump's presidency. While Donald Trump was president of the United States, commander-in-chief of the United States military, he was actively, according to this indictment and statement of fact, dealing in a criminal scheme to cover up payments he made with his associates during the 2016 presidential campaign. Checks being made in the Oval Office, detailing here a pressure campaign on lawyers to stay in line, all alleged in this indictment and the statement of fact. This is not just about the story of Donald Trump. It's a story about the American presidency being tested in a way we haven't really seen in a criminal sense since Richard Nixon.
The hardest job in the world, which of course is the title of John Dickerson's book. Did I say that correctly?
You did. God love you. Yeah.
But, you know, think about that, because it is, and to be dealing with all of these personal and salacious details, as is alleged by the district attorney.
Right. You should be dealing with other things. One thing that, and again, as you just pointed out, it's quite important to say this is what's being alleged by the Manhattan DA. But what the DA is alleging is not just, oh, here came this story from somebody and we got to clean it up because I'm embarrassed. The DA is alleging in August 2015, the entire catch and kill scheme was created as a place to put bad things that would hurt the election. It wasn't just some bad thing that happened close to the Access Hollywood tape coming out and it was a fast movement. It was, according to the DA, a long, planned-out, methodical effort to subvert the electoral process.
The porn star, the Playboy model, the Trump Tower guy who said maybe there was another baby out there.
Right. And since all of that was paid by funds that were then lied about in official proceedings, that's how this entire big thing was, from its inception, according to the DA, a part of trying to get around the election or election related.
I think it's an interesting idea what the defense could be, which could be embarrassing personally. But what if the case is that Donald Trump and Michael Cohen had been doing this for years, long before the campaign, of paying off women, so that it would not be primarily about the campaign?
Wow, that's an interesting, in other words, they'd done it before. And so it wasn't a campaign finance violation.
Correct.
It would be
I mean, I have no basis in fact for that, but I think it's an interesting defense if I were a defense lawyer, if in fact it's true.
Right. The motivation, it takes away the motivation.
Correct, which is the gravamen of the complaint.
Right. This is just a part of my personal hygiene. And I just happened at this point to be doing this thing that I'd done my whole life while there was a presidential campaign going on, but it wasn't initiated for the purposes of getting around.
Well, and that it is a defense, but of course it creates all kinds of other issues for Donald Trump.
All right. Well, thanks to all of you. This has been a fascinating and historic afternoon, and appreciate all of your reporting and terrific analysis. Just to recap, it was about an hour in court for the former President Donald J. Trump, where he pleaded not guilty to 34 felony counts of falsifying business records. The Manhattan District Attorney's statement of fact alleged it was part of an effort to conceal crimes that hid damaging information from the voting public during the 2016 presidential election. In the words of some, a powerful indictment that alleged a scheme by the former president of the United States so he could get elected president. Well, today, Donald Trump becoming the first former president to be booked, arrested, read his rights. He is now back on his way to Florida, where he will deliver remarks this evening from his home there and private club, Mar-a-Lago. We will continue on CBS News streaming your local news, and we will have a full wrap-up tonight on the CBS Evening News. A big thank you again to our team of our correspondents, reporters, guests, producers, and contributors. This has been a CBS News special report, the arraignment of Donald J. Trump. I'm Norah O'Donnell in New York.